Feedback. Feedback is always good. If you've ever gone for a job and you think you've got everything you need, you think, great, yeah, tick, got that, yeah, I've got experience in that. You apply for it, they want to see you, they see you once, and then you don't hear from them ever again. Now, that might be because the job's gone anymore, it's not there anymore, maybe the budget's gone for it, or they've recruited somebody internally, or they've recruited another external candidate. But it's always really good to know what's happened to that role. And again, it speaks volumes about the business. So it's all about the business brand. And if actually, you've gone for a role and as I say, you think you've got everything you needed for it, and they've registered a lot of interest in you, but then haven't come back to you, what are you likely to sort of think about that business? Probably not very highly. So feedback's really, really important. And again, what you would notice as well, if when you engage with a recruiter, what they'll always come back to you for after you've seen candidates is feedback. They will not leave you alone until they've got it. So I think they see the value in that as well. So then offer phase. We would then want to look at how we would offer that role to somebody. We might give them a call and say, congratulations, you've got the job, or we might email them, or we might write to them, but correspondence with that offer is again really important and representative of the brand. So so that would be obviously a course that would follow after selecting the successful candidate. Another recent really important one is this right to work legislation, and again we will come on to it when we cover case work. But right to work legislation is something that, as part of the Immigration Act, is fundamental. It's the law. We have to do it. So before day one, so before day of starting role, we have to make sure that we have seen, at least seen, but preferably seen and taken a copy of somebody's legal right to work in the UK documentation. Failure to do that would mean that the company is liable for costs involved with a breach of the Immigration Act, and would probably be pursued for that. That includes if somebody brings their right to work and you see that it's a visa that's valid until August 2018, you have to make sure that you follow up with that, because if you don't, and that individual then is found to be working for you past August 2018 and they've not renewed their visa or gained full right to work in the UK after that, you again are liable. So we've recently had a case within my business where that exactly happened, and note had been taken of it, but I don't know, it hadn't been chased, it hadn't been followed up, and it was only because this individual told us himself that he'd applied for his permanent visa and been rejected for the second time, that as of the 5th of January he no longer had right to work in the UK, and we had to pretty much frog march him off site. You just cannot have somebody working for you that doesn't have the right. But it also goes against modern slavery legislation as well. So there's lots and lots of things ethically and with regards to immigration that we really need to consider. And I think that is only going to increase with Brexit as well. So one to watch, I think, particularly with in the field of HR.